Yes.
Thank you, Lord. As I said, I want to move quickly to Fesco, but I urge your Lordship's few answers, so without belabouring any points, if I can just run through those.
Please.
The first is that I said that I would check page 1 of the Transnet skeleton,
Yes.
which was the reference from miscellaneous bundle, page 49, which included the sentence, the courts invoked, the claimants invoked the court's jurisdiction on false premises, both legal and factual, with multiple matters withheld and or unfairly presented at the ex parte stage. No reference to the Russian state point at all. It's an entirely general statement. Haven't been able to find anything in the time available in transcripts. Maybe looking for that. As to the approvals point, your Lordship asked me whether the clause 4.3 point arising out of the SPA had been raised specifically, so far as I can see, by the claimants, that is, in answer to this contention. It's of course all a debate that arose quite late because it came up in reply, but so far as I can see, the debate as to what the requirement for closings meant is a debate that was explored, but I do not find specific reference to clause 4.3, and I therefore do not say that there was such reference. Answer to your question.
But was there an argument that the approvals weren't even needed, which is the argument you're basing on that clause?
The argument, as I understand it, was that there remains a good case, but it was not the specific point that, amongst others, I raised as to the effect of clause 4.3. I have not been able to find a reference that was correct. Clause 4.3 does say that, but nevertheless. In the same context, I dealt with the role of Mr. Karmakov and how the fact that the conclusion on his signature of the SPA really carries through, and I was wanting to give your Lordship a reference to the judgment, and that's just for your Lordship's note, judgment, paragraph 237 and follow. And lastly, on the approvals point, the point I didn't make, but I'm not going to belabor, is when reflecting on whether it's fair presentation, it didn't occur to Transnet at the jurisdiction stage. It didn't occur to Transnet even in its first evidence for the jurisdiction stage. It only occurred to Transnet in reply, and that really ought to give it a sense of proportion. And then as to the other grounds that I have then not dealt with that relate to the NCSB, my suggestion is that what I do is turn a deal with Fesco, we see where we are, and at the end, as it were, I just identify the way the grounds fit together. So I have not dealt with all of the grounds on the NCSB conspiracy that follow consequentially, but I will do so then at the end in that summary. So if I can turn against that introduction to Fesco, there is, again, unfortunately, a point I need to get out of the way first, and it is this. In substance, His Lordship Mr. Justice Bright upheld the challenge in regard to the TPG parties and Mr. Garber, so that's the 1 to 7 and 21, their challenge to the case. In the alternative, on the strikeout basis and on the summary judgment basis. And why is that important? The test at strikeout, from a strikeout perspective, is a test which has reference to pleadings and what is pleaded and what inferences can be drawn from what is pleaded. The test on a summary judgment standard is in substance the same, but it allows for some evidence to have been produced. And so, a point that has been made in the responding notices by the TPG parties is that insofar as the application for permission to appeal and now the challenge to the decision made refusing permission to appeal is premised in the approach to the evidence, that does not address the problem of strikeout. And conceptually, so far, one can see why that point is made. But the difficulty is that the judgment does not discriminate between the two. And can I just show your Lordships what I think are the critical passages in the judgment? just to deal with this point and then make my submissions about it. So in the judgment, which is in Core Bundle tab 5, at paragraphs 83 and 84, His Lordship, Mr. Justice Bright, or sorry, 84 and 85, I beg your pardon, His Lordship Mr. Justice Bright dealt with the tests as to when particulars of claim may be struck out, that's 84, and 85 as to when summary judgment or reverse summary judgment can be granted, and concludes that the tests are materially the same. That's at the end of paragraph 85. And then if we go all the way down to judgment paragraph 485, just turn there, your lordships will find on page 241, quite a long way down, after all the serious issue points have been dealt with. I'm going to come back to that. In turning to gateways, in paragraph 485, His Lordship Mr. Justice Bright records, in the event I have found that the claims against TPG and Mr. Garber in unlawful means conspiracy should be struck out or summarily dismissed. So the judgment certainly shows the judge had in mind both different questions to that extent. Now, having seen that, there is not in the judgment a separation between an analysis of serious issue to be tried for purposes of strikeout on the one hand and summary judgment on the other. And so in all of section L of the judgment, which deals with serious issue, paragraphs 359 to 475 on the Fesco conspiracy, everything is just considered together. The judgment does, of course, conclude that there is no serious issue to be tried, as against both the TPG parties on the one hand and Mr. Garber on the other. But so far as I can see, it does not divide the analysis so as to identify grounds upon which it might be said it should be struck out and grounds on which it might be said otherwise that the summary judgment standard is satisfied. And if we then go down to paragraph 577 at the end, on page 257, Fesco conspiracy, the unlawful act conspiracy claims in relation to the Fesco conspiracy fail as against TPG, Dominias, Felix, DPO, Fesco, Mr. Garber and GHP, on the basis that the claims have no real prospect of success and or there is no serious issue to be tried as against these defendants. So again, does not distinguish between the two. And if one then goes to the refusal of reasons by His Lordship Mr. Justice Bright for permission to appeal, so the short reasons, they are in Core Bundle tab 6, page 262, and include on that page in the second paragraph, in relation to the Fesco conspiracy, jurisdiction effectively depended on the claimants establishing justiciable claims against the defendant served in England, TPG and Mr. Garber. I have struck out the claims against TPG and Mr. Garber as unarguable. Again, dealing with it in something of a sort of collected and summary way. So the TPG respondent's notice, and I'll give you the reference, it's miscellaneous bundle tab 15, page 65, paragraph 3 to 5, seeks to make the point that the strikeout test and its application, and that it might have itself justified the result of the case, have not been addressed in the grounds or in the appeal and in this application. It's not entirely right, because ground one of the grounds of appeal is expressed to cover both serious issues to be tried and a reasonable basis for bringing the claim, and it is then addressed in detail in the skeleton. But what I wanted to go to was Lord Justice Males's decision, which is application bundle page 21, to see how he then dealt with those grounds. And you'll see the statement of the relevant principles, and obviously I'm going to come to this in more detail in paragraph 2, so that the judge had set out all of the principles, and in paragraph 6, that the judge did not lose sight of the principles, and then was entitled to conclude towards the end of that paragraph, applying this approach, that there was no real prospect of success / no serious issue to be tried, so far as the Fesco conspiracy against those defendants is concerned, and that's sufficient to dispose of the case against them. And that too, quite understandably, given the background that I've just shown you, focuses on a combined evaluation. It too does not distinguish between, and I mean no criticism in that respect, between strikeout and summary judgment. And in our submission, the result is, it just isn't, whilst I understand that level of principle, the point that those defendants are making, it just isn't possible on the judgment to isolate analysis which is only for purposes of strikeout from analysis which is for purposes of summary judgment, or at least be very, very difficult to do, and I certainly cannot do it. And in our submission, it would be wrong to approach the question both of permission to appeal and this application upon the basis that there is a clearly defined judgment, grounds of decision as to strikeout, which can be separated from summary judgment and which stand independently of any attack on the evidence. We are, in effect, driven to deal with the two together because that's the way that it was approached. So that's the submission. I want to then turn to Fesco's serious issue to be tried directly. Can I recap?
So you're not making any submission that was an issue that needed to be considered. You made those points leading to your ultimate submission to explain why you are dealing with the two together.
Exactly. Yeah, it was. I do not make that, to be clear, as a criticism of Lord Justice Males.
Yes.
To the contrary. In this instance, to the contrary. It seems to me that he was driven, as I am today driven, we are driven, to deal with the two together.
Yeah, okay.
Yes. Yeah, I hope that's...
I understand. Yep.
I addressed the point because it was raised in the respondent's notice. At its highest level, the core point as to Fesco involves the proposition that there was a failure by the judge to properly allow for the way in which different parts interrelate and stack together to establish the serious issue to be tried as to the conspiracy and the involvement of these particular conspirators. And that instead, what was done was to disaggregate and look on a siloed basis, if I can use that word, at specific facts as against each, and consider inferences that might be drawn from those facts in isolation from the greater picture. And that had the greater picture been looked at, and indeed having regard to points on which a serious issue to be tried was upheld, there really was a compelling case for an inference against the others as well, including the TPG defendants and Mr. Garber, who are for present purposes critical. And that when it came to the decision on the application for permission to appeal, when it came to Lord Justice Males' decision, Lord Justice Males did not grapple with that core problem. Some individual points downstream, but that is the as it were, the headline point. What I, in that sense, want to deal with. First, just to recap as to what the court actually found. So on the Fesco conspiracy, the court upheld the serious issue case at that level against the ninth defendant, Magomedov, focusing on its obtaining of cypriot injunctions to stop the voting of the shares in Fesco. against Ms. Mamadzad, the 10th defendant. Sorry, I'll give you the references. Judgment 406 in regard to Halimeda. In regard to Ms. Mamadzad, judgment paragraph 401. In the light of the case as to her first beginning to assist Mr. Rabinovich and Mr. Severilov, but in particular her letters to the Magomedov-sided, the SGS-sided nominees for directorships, persuading them to withdraw in September 2020, for which there was no explanation. A serious issue was established against Mr. Rabinovich, that's the 11th defendant, the party associated with him, that's Mr. Severilov, the 15th defendant, the company, that's Erminosa, the 12th defendant, and in turn,
what was Mr. Severilov?
Connection.
Severilov, sorry, which defendant was he? Number
15.
15. And then you were going to say.
And then Erminosa, the 12th, and Ross Atom, the 17th, and that's judgment 378. And the serious issue against them was particularly referenced to their involvement in 2 meetings in August 2020, the first of which, at which it was made clear that there was a corporate raid being undertaken to obtain the SGS part of the business, and a suggestion that it be sold out for 150 million, a fraction of its real value, failing which it would be dealt with, and then a second meeting at which a threat was made, and that it was specifically identified as creating a serious issue to be tried. And then lastly, Mr. Kuzovkov, the 13th defendant, in particular because there was evidence to support an allegation that he may have been bribed, some 20 million.
Sorry, who's that? That's
13, 1-3.
Where's that sound coming from?
Sounds like it's coming from outside.
I
Would you be able
don't
to
know.
check out in the corridor, please? It sounds so.
I'll have to rest with the answers, not me.
It's all right, I think it stopped. Okay,
Sorry, so.
it was
Sorry.
just a bit distracting.
Distracting.
Of course.
So we've got as far as the
So I had dealt with
2 meetings, and then D, you said D13.
13, Mr.
Which is-
Kuzovkov.
Yes.
This was judgment paragraph 386, and you would find reference there to the fact that he may have been bribed, and his conduct may have had something, in turn, his and Ms. Mamadzad's conduct may have been influenced by that in dealing with the 3rd of September board meeting. To make clear, and I'll come to the Fesco board, Mr. Kuzovkov and Ms. Mamadzad are both directors on the Fesco board at the relevant time. Ms. Mamadzad, indeed, the chair. So all of that was found, but against the others, rejected. And grounds of appeal 1 to 6, if one looked at just at the grounds, are addressed, dare I say, in considerable length in the permission to appeal skeleton over some 37 pages. But the particular point I want to make about it is points are repeatedly made about the interconnection between those grounds, and that the individual grounds in turn bear on the whole, but also have points that are individually applicable. And therefore, the submission is that what was required was to look at grounds 1 to 6 both individually and as to their interconnection. And then turning to Lord Justice Mayall's decision, back to application bundle tab 3, page 21, those grounds, that is grounds 1 to 6, are collectively addressed by paragraphs 2 through 6.
So 1 to 6 concern.
1 to 6 concern variously, just to that they are by party, my lord. So ground 1 is TPG, that's the 1st to 7th defendant. Ground 2 is Domidias. Ground 3 is Felix. Ground 4 is DP World. ground 5 is Fesco, and ground 6 is Garber.
So these are the various defendants where the judge did not find there was a serious issue to be tried.
Yes, -1. There was number 23, GHP, against whom
Yes.
there was a finding but no appeal was put up. So yes, subject to that, it is the defendants against whom it was found there was no serious issue. Just as to where it goes, ground 7 then deals with the contract gateway, ground 8, the protected, necessary and proper party gateway, grounds 9 and 10, the forum questions, and those are the Fesco grounds of appeal. So coming to His Lordship, Lord Justice Mayles, in substance, as you will see, it's grounds 2 to 6 that respond to, reasons 2 to 6 that respond to grounds 1 to 6. Paragraph 7 then deals with ground 7, paragraph 8 deals with ground 8, and paragraph 9 says grounds 9 and 10 don't arise. So, they dealt with collectively, and what is the decision? The decision, or the reasons that are given, is that paragraph 2 and 3 are that the legal principles applicable were comprehensively set out, and there is no challenge, paragraph 3, to the correctness of those principles. I'm going to come back to that. And then paragraphs 4 and 5 respond to a point put up in the permission to appeal application as to the fact that it is submitted, the judge conducted effectively a mini trial rather than applying properly the principles as to how good the case has to be to establish a serious issue to be tried. And it said that despite setting the principles out correctly, the judge failed to apply them and conducted a mini trial. So Justice Mayles sees that, identifies that criticism, identifies in paragraph 5 that it's fundamental, and says it's fundamental because grounds 1 to 6 effectively repeat the detailed submissions in the case below. And then paragraph 6, but it is apparent, as he said, from a fair reading of the judgment as a whole, that the judge didn't actually do that. He did not lose sight of the legal principles, and then reach the conclusion that he was entitled to reach the factual conclusions that he did. He was entitled to find that there was no real prospect of success. So that's the decision I have to address for purposes of this application. There are important legal principles, and we do say that there is a respect in which Lord Justice Bright did not identify relevant legal principles. Can I just make clear what I say about that? And it's helpful to start actually from a point on which this is not focused, but nevertheless it's going to feature in debate, which is the principles as to unlawful means conspiracy in general, which the judge had set out in paragraphs 151 to 165 of his judgment. And there's no challenge to that analysis. But what it comes down to is it's necessary to establish combination, concerted action pursuant to the combination, unlawful means and intention to injure, but conspirators can join at different times. The unlawful means need not be independently actionable, and not every conspirator needs to have taken unlawful steps themselves. And for reasons that I will come to, each conspirator does not have to appreciate that the relevant means that they knew were part of the concerted action were unlawful. In other words, they have to know about the means, but the question of whether of their unlawfulness is an objective question. And the conspirators must have shared the general intention to injure. Really, that's not an issue in this case, in the sense that everybody's associated with the campaign to strip the Magomedov side of things of their shares. So then the judge turned to, there is the serious issues, there is the legal principles applicable to the evaluation of serious issue.
There's no challenge to the way the judge set out those principles.
So I was being clear, the judge set out correctly principles applicable to unlawful means conspiracy, there is a particular respect in which we say that the judge may have misapplied those principles, and I'll identify it now. It is the question as to whether there needs to be an appreciation on the part of whichever defendant one's looking at, so whichever conspirator one's looking at, that the relevant means that they did know about were in fact unlawful. And the authority that you don't need that is the Racing Partnership's decision of this court in Main Authorities Bundle.
And did the judge refer to that?
I don't think so, but there's nothing wrong with the parts they did refer to. My point was to say there is this little niggle of an issue. It is important to have in mind the principles of unlawful means conspiracy. This application has not suggested that the principles summarised from the cases summarised in the paragraphs I indicated were incorrect. Is that an answer to your question? So then, as to the legal principles applicable to evaluating serious issues to be tried, the PTA, the Petition to Appeal skeleton, had in fact put up material submissions as to the ways in which the principles set out by the judge, whilst correcting themselves, did not fully reflect the proper analysis. And there really are 2 points. And the first is the mini trial point, and you've seen that in Justice Mails's reasons. It's Permission to Appeal skeleton paragraph 9, core bundle page 35, pointing to authorities to which the judge did not refer about avoiding a mini trial at the jurisdiction stage. There are many, but the most referenced one is the Okbapi versus Shell decision at the Supreme Court in 2021, which is in Main Authorities Bundle Volume 6, tab 34. And just for your notes, if needed, the relevant passages are at paragraph 101 following, and especially 109 to 12.
And the judge knew that he shouldn't carry out a mini trial. He said that he referred to the...
I think that's right. He didn't actually refer to this case, but the question isn't whether he knew it or didn't know. The question is whether he did it. And then, so far as Lord Justice Mails is concerned, Lord Justice Mails understood that the challenge that was being raised in the Permission to Appeal application was as to the judge's approach and whether it constituted a mini trial. So far, so good, Lord. But if I can finish and then perhaps see if we understand where we are. But there was a second and connected point, which is the importance of looking at the evidential material as a whole and not looking at it in a compartmentalized and siloed way. And that's in paragraphs 30 to 31 of the Permission to Appeal skeleton, which makes the submission that the court's approach failed to do that. In other words, it did look at it in a compartmentalized and siloed way. And the law in that respect, the Permission to Appeal skeleton refers to Lacatania Shipping, decision of His Lordship Sir Justice Bryan, also in the Main Authorities Bundle, Volume 6, tab 35. Now, that really is the body so far as this assessment of principles is concerned. Can I just get another point out of the way? The respondents have made the point that the judge did also refer to the question of what inferences you can draw when analysing pleadings as distinct from evidence. And that's judgment paragraphs 100.
Right, that was Lacatania Shipping, which...
Main Authorities Bundle, Volume 6, tab 35.
Which paragraphs?
Page 1619, paragraph 65, which is in the bundle at page 1636. Have I taken that too fast in order to get that reference? And it's referred to in Permission to Appeal skeleton, paragraph 30 to 31.
No, I'm just saying, because I mean, the judge did refer to that authority.
Yes, but I don't think to that point, but
that's why I was asking.
I speak under correction. Can I just give one further point? There was another set of principles which the judgment deals with at paragraph 168 to 171, which relate to the analysis of pleadings and when it is legitimate in a pleading to infer from previously pleaded allegations. something different. And there are some judgments that apply to that, including a case called SOFA and Swiss Independent Trustees, and including JSC Banker Keckman. And I completely accept those principles are not challenged in this appeal or in the attempt to appeal. But they are not the focus of this application. And so what I want to do, what I would like to demonstrate to you, is why we say, firstly, that His Lordship Mr. Justice Bright did conduct a mini-trial and did not keep the context of all of the different points together, but instead treated the evidence in an inappropriately siloed way. It's identified at length in the skeleton. It is summarised, for your Lordship's note, in Permission to Appeal skeleton paragraphs 25 to 27 on page 44. But what I would like to do, if your Lordships will allow me to do, is just to explain why the point's a good one, and then we'll come back to what His Lordship, Lord Justice Mail, said about it. And I just want to pick a central example for that purpose, which is the 3rd of September 2020 Fesco board meeting. And your Lordships may or may not be on top of this. That meeting took, for present purposes, 2 material decisions, and by implication, perhaps a third or perhaps not. It replaced the then managing director or president or whatever he's called of Fesco with somebody new. And secondly, what it did is it authorised its subsidiaries to pursue the subsidiary debt owed to them by the companies higher up the chain. Do your Lordships understand what debt was owed by who and its essential structure? I should perhaps just show you on the organogram what we're talking about in very rough terms.
I think so, but why don't you do it just to make sure?
I'm just going to do it quickly to just identify who we're talking about. So if we turn to the bigger organogram, which is at tab 7, page 361, just to have the virtue of the bigger copy in the core bundle. And if your Lordships have that, you will see towards the bottom in dark blue Fesco,
yes,
TJC, and below Fesco are 3 subsidiaries that are identified. There are, of course, others. And the one in the middle is Halimeda International Limited. That's a Cyprus company and is a defendant in these proceedings. And there were loans from Halimeda to 2 of the companies in the blue structure on the left, and they are Maple Ridge Limited, which is a Cyprus company 3 layers up.
Yes.
And Cyan Corporation, a BVI company,
yes,
in the layer above it. So the intercompany loans that concern these decisions lie between those parties. And what happened at the 3rd of September meeting is that it came up for decision as a matter for Fesco as to whether Halimeda should institute proceedings to recover those debts from Maple Ridge and Cyan. And that decision was adopted. Those are the decisions that we are talking about.
So the assets of the company were used to buy itself.
In fact, came a little bit later, but in a sense that's right. There was originally a financial structure which was then replaced with an intercompany financial structure, and that intercompany financial structure, in that one-step indirect sense, financed the ongoing acquisition of the shares, or provided the ongoing finance for what had been the acquisition of the shares. That's the best way to put it. And of course, those companies, in that, when you look at those companies, the assets are Fesco. They're not other assets. So one of the striking things about this decision, it's not that it's an impossible decision.
Is that I mean, you say that it's self-evident just by looking at this picture, but it's obviously not self-evident because
No, it's
they
a
might
case
have
that
other
was
assets.
explored.
Right.
It's a case that was
So
explored.
there was evidence about that.
There was evidence about it. There were also there were some cross-cutting claims between other parties, which slightly complicate the position. But the essential point is that to repay the full extent of that intercompany indebtedness, the assets that would have to be deployed by Cyan and Maple Ridge would be the stake that they have indirectly in Fesco itself. That's the point. And I don't think that there was any debate about that. That is in fact the position. That doesn't make it necessarily illegitimate, but it's nevertheless the starting point.
It's not even prima facie illegitimate, is it? Because there are all these other shareholders. But,
No, all of that is right.
I mean, I can see if it was 100%, you might say, well, this is bizarre, but it's not.
And I didn't put it that high for exactly that reason. My only point is, of course, if there were other assets sufficient to service the loans, it would be entirely different. But in circumstances where, in effect, what's going to happen is ultimately execution against the very shares in Fesco. So what it involves is one of the subsidiaries say to one line of Fesco shareholders, and it is one line, it's a 49.99% line. Effectively, we're going to execute against your own shares in Fesco. That's how it's going to work. So you can take that decision, but that's what it involves. Now, there had been an alternative to that. And the alternative had been something called Project Moonlight, and your lordships may have seen it. Project Moonlight had been a project to restructure the intercompany debt.
If I picked it up, it was in respect of one of these two companies, but not both. Is that right?
No, it affects this whole line.
I thought it was in respect of Maple Ridge, was it? But
So far as I know, I'll check.
I may have got that wrong.
My own history suggests that it would have affected both, but there are two separate sets of debts, and in different arbitration proceedings, those have been dealt with. So Project Moonlight was to restructure the intercompany debt. It was approved by the Fesco Strategy Committee, which is a subcommittee of its board, in April 2020. Party to that decision, as directors, were the then chairman of the board, the then president of the company, the CEO figure, Mr. Sakharov, and Mr. Garber, and Mr. Schwetz, who is the director appointed at that time to represent the TPG stake in Fesco. They were on the strategy committee that recommended that. And it was supposed to come up at a board meeting in April. That board meeting was then delayed by Ms. Mamadzad without explanation. And time went by and it was not addressed. And then she, on the 2nd of September, called an emergency meeting for the 3rd of September, at which a decision was taken about Halimeda's.
Sorry, I know I don't want to be pedantic, but I am just looking, because I want to just be clear about this.
It is important, my lord.
The judge said the Project Moonlight recommendations do not appear to have affected the Cyan loan, which is on paragraph 75.2. So he seems to think that it only affected the Maple Ridge loans, but also some others, but not the Cyan participation loan.
And your lordship may be right, and I really,
anyway,
you
say
do not want to mislead the court in any way.
Well, I know, that's why, but these things may turn, I don't know whether they're important or not.
Yes, I don't think probably
but the point doesn't, if there is a point here, it doesn't affect the other loan, in respect of which the decision was taken on the 3rd of September to seek to recover it.
That is correct, is that the decision on the 3rd of September was about the Maple Ridge loan.
And the Cyan,
so far as I
and the Cyan loan.
But so far as I understand, restructuring was under discussion to restructure the intercompany debt as a whole.
Well, that's not what
Project
the judge
Moonlight. Your lordship is making a point about Project Moonlight, and I do not contest that paragraph of the judgment. Project Moonlight was a partially developed proposal towards restructuring The point for present purposes is the strategy committee of Fesco thought it a good idea to undertake this restructuring, and that was pursued, and advice was taken from Cleary Gottlieb relating to whether the directors would breach their fiduciary duty by recommending it, which they concluded that they would not. And the thing rolled on, and then precipitately, having delayed the board discussion of it, Ms. Mamadzad called a board meeting on one day's notice to be held electronically to decide to support Halimeda pursuing Maple Ridge. That being, by implication, a rejection of, but in any event, wholly inconsistent with all of the discussions about restructure. And there was no proper debate at that meeting about all of that. I think I've now put it in a secure and safe way, because I really do not want in any way to pick on anything that's incorrect. The board then takes this rather odd decision, and various things happen at the same time, and they are these. First, that very shortly thereafter, Halimeda seek injunctions in Cyprus, the effect of which is not just to stop an attempt to reverse that decision or something like that, to interfere with that decision, anything of that kind that might or might not have been argued, but to stop all of the directors in the SGS line, in the blue line of this organogram, all of the directors appointed to serve those interests it's not the directors, I beg your pardon, to stop the shares being voted at the annual general meeting, to stop that entire 50%, 49.999%, being voted at the forthcoming annual general meeting, then scheduled for the 30th of September. So it, in fact, was delayed for reasons of quorum, but it was scheduled for the 30th. So that's happening at the same time. At the same time, Mr. Garber is selling Dimidias to Mr. Severilov. The agreement was never produced, but Mr. Garber's evidence was that took place on the 28th of September. And you'll see back in the organogram, Dimidias is the controlling shareholder of the orange part of the diagram, controlling a further 25% of Fesco. At the same time as that was going on, you had everything that the judge did find a serious issue to be tried about, which is in August, the emergence of Rosatom, Mr. Rabinovich, and Mr. Severilov, the corporate raid being announced on the SGS interests, and ultimately a threat being made that unless they sold out for 150 million, steps would be taken, which gave rise to a serious issue to be tried. Where do they fit in? Mr. Severilov is the purchaser of Dimidias, and Mr. Rabinovich is interested in Erminosa, as you can see in the organogram, and Erminosa acquired Felix, which was the other shareholder in the top of the BVI chain of companies leading up to Intermere Investments Limited. And that's the TPG entity. So that's at the same time.
Also at the same time, I mean, actually the dates are very important, aren't they?
I can be more specific.
So that's before the agreement between TPG and Erminosa. What's the date of that?
Well, it's the ROFO transaction, as it's described, right of first offer refusal transaction. And what the Intermere shareholders agreement provided was that if one of those two parties, SGS or Felix, wanted to sell their shares, they had to first make a right, effectively offer the other a preemptive right at the same price.
But the way that tends to work, I don't know if it's the case here, is that you do that once you've got an agreement with a third party.
Quite simple.
So when was that?
Yeah, quite so. So what happened is that the underlying agreement between TPG and Erminosa is concluded in July.
So that's before all of these meetings and the August meetings and the
Yes, a couple of months before.
So
yes.
TPG at that stage is saying we want to get out.
Well, it goes slightly further than that, but yes, that's right.
For 35 million.
Yes, that's right. This being the subject, all of this was the subject of an arbitration that is on the merits run its course, although its final consequences remain still to be determined. So the right of the underlying agreement is concluded in July, and in order to satisfy the obligation to make an offer to SGS, they are then sent a draft SPA for the 35 million. As it happens, they are not given the actual contract between TPG and Erminosa, and that's quite important. They're given a distorted version of what the SPA says, and all of that was the subject of the arbitration. It's quite important because in the actual contract, and all of this was dealt with, is in the pleadings and in the evidence. In the actual contract, TPG undertook to use its efforts to support Erminosa in defending a position that the SGS would not be able to buy. That SGS would not be entitled to buy. So they were buying into the success of it, including to respond to it. They weren't just standing back as a third party, Erminosa as a third party seller, saying, well, you guys just do whatever you do. We go through the process and I'll sell to whoever I sell to. It wasn't like that at all. They were setting about achieving a result in which, in the end, Erminosa would acquire and SGS would not trigger its first offer right. And then followed the history that is dealt with in some length in the particulars of claim and in the judgment, which is that process ran through its course. SGS said it did want to buy. It then had to raise funds for that purpose. It discussed, in fact, doing so with DP World, who later turned out to be entering into a joint venture with Erminosa. So it lost them, ultimately found some alternative financiers, ultimately found some money, put up the money, and there was a litany of debate backwards and forwards about anti-money laundering requirements and the like. And in the end, what was contended by TPG, now Erminosa, is that they had failed to go through and satisfy the requirements to purchase out the preemptive right. And all of that was held to be a breach of the agreement in the arbitration. And that process takes from July through to October, effectively, even November. So when I say it's happening at the same time, before and after, and your Lordship is right, the dates are important. The allegations as to what was happening with Felix span the months in that sense. So all of that is going on. The threat is made by the Rabinovich parties at the end of August, as I said. You see what I've left out. And the bribe. And there is the bribe that is found affecting the conduct of Ms. Mamadzad and Mr. Kuzovkov, and that's a judgment, paragraph 341. And in September, Ms. Mamadzad sets about persuading the director nominees not to participate. So the judge finds on individual bases that some of those points are good, some of them are bad. It rejects the Felix point, and I will come back to that. But nevertheless finds that there is something going on here. But what I do want to show you then is how the judge approaches the assessment of some of the related facts, which is when the judge then turns to address the decisions at the meeting, the decision to support legal proceedings, implicitly abandoning Project Moonlight. It finds that variously that the delay from April in considering Project Moonlight and Ms. Mamadzad's evidence as to her concerns about it seem objectively reasonable. This, despite having found she is a conspirator, or is at a serious issue level a conspirator, but it seems objectively reasonable. That's judgment 419 to 420. As to the decision to pursue the intercompany debts, finds that there's nothing inherently striking about such a decision. That's the language. That's judgment paragraph 422. Then, as to why Moonlight was not in fact discussed at the 3rd of September meeting, places weight on the evidence of Mr. Kuzovkov, which was to the effect that the majority of the board felt that it was not viable. And Mr. Kuzovkov is the bribe taker who has been bribed in a way which his lordship had accepted, affects his approach to the 3rd of September meeting. But nevertheless, places weight on that evidence.
How does that really matter? Because he's found that there is a claim against him.
No, I'm dealing with where you get to on everybody else. But
but why does that involve anybody else? You might say, well, those things might have caused the judge to say even more strongly that there was a serious issue against those people. But the point about grounds 1 to 6 is whether you can join in the other people.
No, that's entirely correct. So TPG's Mr. Schwetz is one of the directors. Mr. Garber is one of the directors.
But they're not at the meeting.
Mr. Garber participates in the meeting.
Yeah.
Mr. Schwetz chooses not to participate. I'll come back to it. But they obviously could have been, and in some senses should have been, at the meeting. I'll make some submissions about. If it is suggested that the decision to pursue the intercompany debt and to shelve Project Moonlight is, as it were, a decision untarnished by any greater conspiracy, and one which, as the judge puts it, might reasonably have been thought to be in Fesco's interests. They're appearing at that point as the Fesco board. And I'll come to where his lordship says that. Then it matters as to why was Project Moonlight not debated and what did anybody say about it. The evidence upon which the judge placed weight in that respect, that is to say, that the majority of the board thought that Project Moonlight might not be in the interests of the company or that it might not be viable, is Mr. Kuzovkov's evidence. My point for present purposes, my lord, taking your lordship's point as to what that says about Mr. Kuzovkov himself, is that on a serious issue to be tried analysis about the greater conspiracy, to rely in order to displace inferences which might otherwise be drawn on evidence given by the bribe taker is an inherently surprising thing to do. Of course, at trial, people would be cross-examined and their evidence would be addressed in detail. And it would be possible to rely on some parts of evidence that are given and not others. And the fact that he was a bribe taker, if established, would not necessarily mean that all of his evidence would fall to be rejected. But that is on a trial standard, not a serious issue to be tried standard. And so at paragraph 426,
I noticed that when he's dealing with what happened at that meeting, he doesn't just rely on what Kutuzkov says, he also relies on what Mr. Garber says.
Yes, so I'm trying to do, but the trouble is, as in all conspiracy cases, it is a stack of strands. And your lordship is right, that there are other strands. And what I'm trying to do is bring them all together.
Yeah, but you're trying to say, you're trying to explain to us why ultimately Lord Justice Mayles has gone wrong when he, in relation to grounds 1 to 6, when he said, well, the judge went through all of this very carefully, he found that some people were involved in the conspiracy, but others weren't. And there isn't a proper ground of appeal, an arguable ground of appeal, that the judge's assessment will be overturned in relation to that. Now, you've given an example. You've said, well, look, Mr. Kutskov is a bribe taker, so why should anyone listen to what he says? But the judge, in fact, on that very paragraph, relied also on what Mr. Garber said. And Mr. Garber, he has not said was a conspirator.
No,
So,
I'm coming to Mr. Garber.
well, I know, but you then say, well, how can the judge give weight to this evidence?
But Lord, let me be clear. I completely accept there is a big and complex problem.
Yeah.
What I'm trying to identify is the reason to say why these things are all interconnected, and why it might be said that there is an argument that the judge focused on some things at the expense of other things. I completely accept one's then got to draw it together and see where you are, and that I need to address you both specifically on Mr. Garber and specifically on TPG. But I can only do it one thing at a time. Yeah, I apologize for taking so long to do it. So the point I wanted to make was that in paragraph, the next one was paragraph 426 of the chapter. The Lordship finds it's entirely possible that the board could have held the view that Fesco was in urgent financial trouble in good faith, despite the evidence that it was not. And then in paragraph 427, finds that, and this is very important paragraph, if I may say so, finds that even though it would be possible to infer that the circumstances relating to the meeting arose from the Fesco conspiracy, unpacking that presumably, that the meeting is a concerted step in the execution of the conspiracy, ultimately, His Lordship Justice Bright decides he did not so infer, and instead concludes that it's not possible to infer that the steps at the September meeting were taken pursuant to the conspiracy, and it is more likely indeed that the directors genuinely believed, rightly or wrongly, that they were indeed acting in best interests. Now, of course, that involves, as you've just put to me, weighing points on the one side against points on the other side. But it does appear to be language and an approach which, at least it might respectfully be said, inverts the inquiry from one into whether there is a real prospect of success, serious issue to be tried, non-fanciful claim, and into one which is whether the claim is in fact well-founded.
But isn't this his point about, isn't this just based on the judge's recitation which you accept about pleadings?
Well,
which is the I can't remember the name of the case now, but the decision of...
You're talking about the SOFA decision, Milord.
Exactly.
Yes. Which
says, and it's based on the Three Rivers decision.
That's ultimately right.
But where you're trying to rely on inferences rather than pleading that someone actually said something, for example. So it's just an inference case. The question is whether, as a matter of pleading, the inference is more likely than not, just looking at the facts which are pleaded. And that's a pleading question rather than a trial question.
Of course, Your Lordship is right, which is why I took you first to the argument about whether this is strikeout or whether this is summary judgment, and what is having regard to the evidence and what isn't. And to which my rather unsatisfactory answer was that the judgment doesn't really permit us to disaggregate, to divide, to distinguish those two analyses.
Right.
But I do accept, Lord, that the decision under the SOFA case as to what inferences can be legitimately drawn is, for purposes of the strikeout application, a correct principle that falls to be evaluated. And I didn't attack that principle. Yeah. Now, what we say, my Lord, is that in all of that, and I want to bring it together, we say there's those who were let off. There was a much more serious case against them than was given credit when you keep, in a non-siloed way, all the moving parts together. So, and I just want to run through that. Just focusing first on the individuals so far identified in that conduct. We've got Ms. Mamadzad and Mr. Kuzovkov part of the conspiracy, tied back to Ermanos and Mr. Rabinovich and Mr. Severinov. We've got Ms. Mohammedzad strikingly called the meeting on an urgent basis and could not explain why. We've got the key decisions, which were to abandon restructuring and pursue the intercompany claim, delayed since April, but now taken. We've got those claims were then wrongfully used. The claim against Maple Ridge was wrongfully used to strip the intermediate shareholding structure of their votes at the AGM, which was due to be held less than 4 weeks later. We've got Ms. Mohammedzad pressuring the director nominees to withdraw, and indeed seeking to intermeddle in the exercise of the ROFO rights by speaking to Armenian banks. And we say, so far, the inference that the decisions amongst those individuals at that board meeting were pursued in furtherance of the conspiracy are, with respect, very powerful inferences and certainly should not be rejected, have been rejected at the serious issue to be tried stage. And I then need to get to TPG and Mr. Garber. Now, as to them together, just to recap, they were both members of the Fesco board at the time, and they had both been members of the strategy committee, which in April had recommended Project Moonlight. And they both obviously knew that the board had been delayed from April through to this emergency meeting in September, and that this meeting was then called on an urgent basis. As to Mr. Garber, what his evidence was is that he found out on the 1st of September that TPG was selling out. Now, there's no other evidence about that. TPG selling Felix, which is their half of the share. No other evidence about that. But the date is quite striking, and we say really in coincidence, all of this is happening together. The judgment had found that the sale of the Midias to Mr. Severinov was part of the conspiracy. That's judgment 364 to 365. The seller was Mr. Garber. The judge had found, in the context of the Cypriot injunctions, this is paragraph 404, that it was particularly significant that the injunctions gave control of Fesco to Dimidias immediately before the sale. That's the sale of the 28th.
Sorry, when you say, can I just look at that?
Yes, of course.
You say that the sale was part of the conspiracy.
I've got my reference to judgment 404.
404. I thought you said 364.
364, you said.
I'm sorry, we're talking about two different points, and I may have given your lordship the wrong answer, so I'm going to start again. My first point was, as to the sale of Dimidias to Mr. Severinov, that is 364.
But that doesn't say, does it, that that the sale itself was a conspiracy, as I read it. Sorry, part of the conspiracy. It says the events that ensued as alleged.
That reference is not right. I'll find you the right reference. That
purchasing it.
right. No, but that's actually dealing, 364 is in fact dealing with the threats in August.
Yeah.
So I've obviously written down the wrong reference, and I'll find you the right reference. I do say that the judge found that the sale of Dimidias to Mr. Severinov, or more particularly Mr. Severinov's acquisition of Dimidias, can be linked to the conspiracy.
Well, it may be, and it may be that he, from his point of view, this was a step in this campaign, which was to try and get the interest in Fesco out of the hands of the SGS branch, but it doesn't follow that the person selling it to him was a conspirator.
Can I put that slightly differently back to your lordship? It certainly does not necessarily follow.
Does it follow even at all? I mean, someone thinks this is a good plan. It's part of a way. It's one step in which I'm going to get control, and he goes along to a seller of the asset and says, "Would you sell me this thing?" He's combining it with a whole lot of other steps, and he thinks this is great because I'll end up with majority control. But Supposing that the seller just of some of the shares just says, okay, I'll sell them to you. Why does that even tolerably involve him in a conspiracy?
Well, I appreciate that I'm trying to draw multiple strands together, and that if you examine the individual strand, as His Lordship Mr. Justice Bright did, then that would be the answer, as Your Lordship has just given me. Because it's not enough. What I'm suggesting to Your Lordship is one has to look at the picture as a whole. And so, what we know about Mr. Garber is right at this time, he sells Dimidias to Mr. Severilov, a conspirator. We know that it was found to be particularly significant, paragraph 404, that the injunctions gave control of Fesco to Dimidias immediately before the sale, because there is the coming annual general meeting. And we know, because the judge concluded, that it is entitled, that a trial judge would be entitled to infer that the injunctions were sought by Halimeda in order to assist Mr. Severilov and the conspiracy. And we say, when you put those things together, there is an inference that Mr. Garber is also part of it. What do we know about him? There really are 4 points. The first is he changes his position on Project Moonlight, which he has previously endorsed, at an extraordinary meeting called urgently on the 3rd of September. He sells Dimidias to a conspirator at much the same time. We know that Dimidias had been subject to options to purchase its shares, and there had been an independent set of events, largely going nowhere because the first agreement ran out of time and the second never became enforceable. But there had been options in favour of the Magomedov side, if I can put it that way, to acquire the Dimidias stake in Merbeau. But in the course of that, and it's the only point still relied upon that arises from those events, what happened is, at the time the claim was issued, there were pending option proceedings. They were then decided midway against those alleging that there had been a breach of those agreements. And so the position shifted, and the judge rightly records that you therefore can't take anything from those facts, even though they are pleaded. But in the course of negotiating those option agreements, Mr. Garber negotiates for and claimed to have no recollection of a provision of the draft option agreement signed on his side, but ultimately not becoming enforceable, which would give him a $5 million bonus if all of the SGS interests were acquired without allegation that it was a hostile takeover. Now, what that had to do with the options is difficult to understand. And His Lordship Justice Bright didn't know what to do with it. What we submitted shows, all of that happening in 2019, 2020, is that Mr. Garber is aware that there is an attempt being made to take out the SGS interests. And that's as far as I take it. But
was that by these same people?
The trouble is the option would be an option.
No, sorry. Was this? You say that shows that in 2019 that somewhere lurking there was some sort of plan by somebody to take out the SGS.
It's less articulate than that. He would get because it's expressed in its result, not by who the acquirer is.
So it's not even the same lot of people behind on your case.
Well, you don't know one way or the other, is the point. All that you do know is that he is aware that someone is trying to take out the SGS interests because he negotiates for $5 million benefit in that event, if that all happens. That's as far as it goes. And the only point that I take from it is that consciousness of that he knows there is something going on here. And then you put these other.
Well, he knows something's going on in 2019, and yes. You say he knows some. Therefore, you say he must know something's going on in 2020.
Yes, and he then changes position on the board from supporting Moonlight to voting for enforcement. He gets out, and at the same time, Domitius, that he has just sold to Mr. Severilo, is the vehicle through which control is then exercised over Fesco, and at the same time, the very legal proceedings that he deliberates upon for the 3rd of September board meeting by Halimeda are used to support an injunction to disenfranchise the SGS.
Is he involved in that decision?
Well, he's at the board meeting and it's a decision of, you mean the decision to take the injunction?
Yeah.
Or the decision to, no, the Fesco decides that Halimeda can pursue
right, and that's after Domitius has passed to Mr. Cerebral.
The application is made, it actually happens on the same day, but
anyway, you don't allege...
The application is made before, and the acquisition is on the 28th of September.
Right, but you don't allege that Mr. Garber had any role in relation to the decision to seek the injunctions in Cyprus.
I can't allege. There's no evidence.
I'm only talking about what you've alleged. I don't
correct.
ask whether you can or can't, but what have you alleged?
Not that.
Right.
Correct. But we say all of that stacks up. One really has to ask what was going on here. Can I just deal with TPG and then I'll come back to them both? So, as to TPG, in summary, July to November, TPG was seeking to sell its interest in Felix, which is the minority shareholder in Intermere, to Erminosa, which is owned by Mr. Rabinovich. This is the subject of Ground 3 and permission to appeal Skeleton 80 to 85. And treating it in a summary way, TPG in July contractually agreed to assist in heading off any claim that SGS was entitled to exercise preemptive rights. TPG itself, through Mr. Schwetz, provided SGS with a false and misleading version of the proposed sale when giving it notice for purposes of exercising rights. That's paragraphs 165 to 171 of the particulars of claim. TPG curiously brought Ms. Mamadzad into that email chain when giving that notice, and she, a conspirator, in due course sought to obstruct the availability of the money from the Armenian bank. Again, we just say it's all interconnected. Now, I accept we have to pass the test of serious issue to be tried. It means you have to draw from the pleading such inferences as you can draw on strikeout basis, and you have to regard to those and to the evidence when assessing it at summary judgment standard. All that we say and all that I say for purposes of this application is that there is a substantial argument for looking at all of those interconnections, and from the interconnections infer that all of these parties, including sufficiently Garber and TPG, were part of a conspiracy. They do not, to be clear, they do not all have to know about all the parts of the conspiracy. They do not have to know about subjectively which parts are unlawful. They only have to know about parts which are objectively unlawful. And they only have to commonly intend that SGS will lose its shares, to put it at its loosest, completely loosest sense. And that's the question. Can one, on a serious issue to be tried standard, say there is no real prospect of success when all the evidence is heard and the witnesses are cross-examined of that being accepted? And we say there was plainly a compelling argument for permission to appeal.
This is based on your overarching.
All of this ties together, and I'll now bring it in to show what I'm
Okay.
saying about that. I appreciate that took a while, my lord. I apologize.
That's right.
And we will take a break shortly. So the central argument, therefore, was you shouldn't have disaggregated and individualized. The court did in the process fall into error. There was not conducting a mini trial a proper basis to say there was a serious issue to be tried. And we saw what Lord Justice Mayall said. He just said, well, it's the right principles. The judge was entitled to reach that inference. And what we say about that is, that is a failure to grapple with the central argument as to the interlocking of these points. And it is in its own terms a failure to grapple with the points made in each of the individual grounds against each of the individual unsuccessful conspirator defendants. Because he does not do that. And we do say that if you brought all of that together, Lord Justice Mayall would have concluded, probably have concluded, that there was a case for permission to appeal, which is all that I have to establish at this stage. But I need to show how all of that interconnects. We need a shorthand writer's break. It's probably the best moment, but I'm going to take it as fast as I can.
Okay. How are we doing for time? Well, you know when we have to,
the time will run out.
you know when we have to finish.
I do. That's exactly right. and I accept that. I'm not about to ask your lordship to send that.
Thank you.
Court rise of April.
Doesn't know what it means. Yeah. No, but did the judge say their conduct is tied to the conspiracy?
Not their conduct in relation to the 3rd of September meeting might have been covered by, yeah.
Yes, that's the
Not-
point I
but
was
not-
referring to.
Yeah, but not the bribe.
On Moonlight and whether it applies to both subsidiaries, the evidence, this is Bushel 7, was saying that you have to assume it applied to both. And the finding was that, I don't know basically, but a case was made that it must apply to both.
And there's the massive scale difference.
Now, hang on, Gary, I just need to get this point. Okay. Yeah.
My point.
What are we reading? Yeah, I'm sorry, Gary. I am going to turn to you. I just want to. So, point 1 was J36425.
Yeah.
And how far it goes. Point 2 is this one. Yeah. Which is Moonlight. Submission was. Sorry, and the third one.
And the third one is in relation to 4.3. I don't know if you want to make this point. There was the submission, or submission, that there were provisions to waive the corporate approvals. And
It's not a
resolutions.
waiver. Yeah.
My point is on that one, that you've got the scale of the two different debts that has really made much that matters in the grand scheme of things, because it's 1.2 billion.
Yeah, and the other one?
Well, we can't work out exactly, but it's 100 or 120 or something. That's what.
Mr. Moylan.
You're going to get that out. You're just going to quickly skim it.
No.
Court rise if you will.
You discovered the source of the sound in somebody's phone they've lost or left outside, which was ringing.
Well, I'm glad that at least on this occasion I was right and that it wasn't me. It,
There's nothing worse.
no, indeed.
Yes.
Nor I'm conscious at the time. 2 points just that passed, just to pick them up. The first was as to the extent to which His Lordship Justice Bright identifies concerted action relating to the sale of Dominias.
Oh, yeah.
It is paragraphs 364 and 365 of the judgment, and they go as far as they go. It's a question of what you read into that.
Yeah.
They are debating the proposition that there is evidence of concerted action. So far as Moonlight is concerned, and whether it related to one or both, the submission had been made, certainly on the claimant side, that it is logical to infer that it concerned both. The evidence is a bit unclear, but it is important to bear in mind the proportion of the intercompany debt. 90% is Maple Ridge,
right,
give or take, and 10%, give or take, is Sine. So on any version, the part that really matters is the Maple Ridge proceedings. Those are the ones that will obviously drive through to the value of the share. What I wanted to do then, my lord, is very briefly, because the Lordship will recall, I said that the other point that had to be grappled with, firstly, the interconnectedness, secondly, the individual points in grounds 1 to 6, and one needs to stand back at the mosaic between those two. So I'd like to run through that, then briefly deal, because I need to, with the gateway and forum grounds of appeal.
Yes.
And then return to run through very briefly, in the time that I have left, the remaining grounds of appeal that related to NCSP, as I said,
Okay. Yep.
so that I finish in the time that I have
Thank you.
maximally entitled to employ, if I can put it that way.
Yeah.
So just to run through the other grounds, this is now application skeleton paragraph 18 and following. Ground 1, this is TPG. In addition to all of that interconnectedness, raises the fact that there were claims against TPG.
Sorry, wait a minute. This is, you said 18.
Application skeleton,
Yes.
paragraph 18 and
Got it.
following,
Yes.
is when it turns to the individual ground.
I've got it. Yep.
Ground 1, so I've been addressing ground 1 in regard to TPG
Yes.
as to the conspiracy. But ground 1 goes slightly further than that. It points out that there was also a claim, so an additional claim against TPG for inducing a breach of contract. That is for inducing breach of the Intermere shareholders agreement. That ground was addressed in PTA skeleton 84 to 85. But that ground of appeal and those issues are not addressed in the reasons given by Lord Justice Nails at all, because his reasons are focused only on the conspiracy. Come back to where it would have got anybody. That claim was addressed in the judgment at 539 to 544, and at 542, well, I should say 541. At 541,
Hold on. Yes.
At 541, the court found that the arbitration had established that Felix breached the shareholders' agreement, and that it is reasonable to infer that TPG induced Felix to act anew of the shareholders' agreement. That's 541. But then 542, nevertheless, there is not a proper basis to infer that TPG knew that what it was inducing Felix to do would be a breach of the agreement, which is, I accept, a necessary part of the action for inducing a breach of contract. You have to know that what you're inducing the third party to do will be a breach of a contract in order to be liable under that tort. Now, as to that, I'm not going to go back through the whole history of the arbitration as it's pleaded. It's pleaded in particulars of claim, paragraphs 165 through into the late 190s. And there are further points made in the PTA skeleton at paragraphs 84 to 85. And some of those points are, of course, addressed, or at least some of them are addressed in the judgment. But starting with the decision of His Lordship Mr. Justice Bright, we do say that in circumstances in which TPG was party to the communications about the right of first offer and the submission to SGS of the distorted version of the contract, and had contractually undertaken to Erminosa to support it in contending that SGS was not entitled to exercise first offer rights. The argument that there should be an inference that it knew that all of the conduct which stacked up to the breach that Felix was found to have done and thereby to have breached would be a breach really is not a difficult inference to draw. And going back to permission to appeal, the refusal decision does not grapple with all of that at all. Now, why is that fundamental? That is fundamental because if that's right, if it was arguable that the action against TPG for inducing breach of contract did have a serious issue to be tried, there would have been jurisdiction on that cause of action in England over TPG because it didn't change jurisdiction. And the question would be whether, nevertheless, even though that's not the conspiracy itself, the other parties are necessary and proper parties for purposes of establishing that the case continued here. And we say the interconnection between those facts and the conspiracy, it being part of the conspiracy, plainly satisfy that test. So that in itself would have brought the Fesco conspiracy to the London court.
That seems rather bootstrap sort of argument.
Well,
you say the other parties were all parties to the conspiracy. This was a bit of it. But on this hypothesis, TPG is not party to the conspiracy. And then you say that somehow the other parties who are parties to the conspiracy are necessary and proper parties to the claim against TPG, who is not a conspirator. It sounds quite adventurous.
Let me tell you, Lord, what the parts of that I accept and the parts of that I don't accept, because there are on both sides. And it's a consequence of dividing things up. There is a separate ground 3, that relates to whether Felix was party to the conspiracy, it being the breaching party itself. And I haven't got to ground 3. I do accept that if there is no basis to say that what one might call the ROFO chapter, that the ROFO chapter is part of anybody's conspiracy, then the point I had just made would be a bootstrap point, and your lordship would be right to make that observation. But that is not so if it is accepted that Felix is a party. And I should have put it that way. And your lordship is right. The case against Dimidias is paragraph 21 and following of the application skeleton. And there is the extent to which Mr. Severilov's acquisition, to put it no higher than that, of Dimidias was part of the conspiracy, and that it was significant, so the judge found, that the Cypriot injunctions obtained by Halimedes served to give Dimidias control. And against that background, we do suggest that the case that Dimidias was knowingly party to all of that is a reasonable inference, is a seriously arguable point. That's addressed in PTA skeleton paragraph 86.
But sorry, why is that a separate point that needed to be addressed in the permission to appeal decision?
The point that I had made about the permission to appeal decision is that it needed to consider two things. It needed to consider, in considering grounds 1 to 6 together, it needed to consider the case as to the interconnection.
I understand that.
That's
Yes.
point 1.
Yes,
The
And
second
the-
point that
yes.
I made was that
individual points.
yes,
Yes.
was a different point, which was each of the individual grounds aggregate into relevance to that larger consideration.
I understand that, but this
That's
is
the only point. I
this okay because this seems to be a repeat. That the judge should have decided that there was no should not have decided that there was no arguable case against.
Your lordship is right. Your lordship will recall the problem that I have, which is I also have to say whether you would probably give permission to appeal and so on. And I'm just trying to identify where
Okay.
the particular ground. It's a very quick run through.
Okay,
where the particular
sure.
grounds fit.
Okay.
So that's ground 2. Ground 3 related to Felix. Now it's found that Felix was actively frustrating, breaching, and you can see what all of the allegations were, the preemptive rights to benefit Erminosa. Well, that really should be in my submission QED against Felix. What the judge found is that if TPG was not a party to the conspiracy, then Felix wasn't either. Now, really, the analysis should have run the other way. The breaching party was Felix. Happens to be owned by, or was at the time, owned by TPG. Why is it? If it's going to get its 35 million, if TPG is going to get 35 million either way, why is Felix behaving like this? The logical inference is that all of this is being done in the interests of Erminosa, linked to Mr. Rabinovich and Severilov, who are conspirators. So it really
But the
isn't
judge
party.
doesn't think that there is anything being done that gives rise to inference that
I think that's
TPG, who at that point are in control of Felix,
yes,
are
until
doing anything.
November.
Sorry,
They are well.
I mean,
the
during these
transfer
events.
to Erminosa takes place ultimately in November.
Yeah, so during these events, TPG are in control of Felix.
Yes, but
And-
contractually obliged to Erminosa to help them.
Yes, I
with
understand
the
that
logo.
point. But he's decided that TPG is not involved in a conspiracy. And he looks at the things which you say either TPG did or should have done, and the things that
Well, it's
Felix...
the things that Felix did.
All right,
really.
Felix
Yes,
did.
it's
So all the
things that
stuff
Felix
about
did.
money laundering and
That's right.
not appointing directors as quickly as they should have done and so on. But he decides that that doesn't give rise to an inference of that TPG were involved in this combination. And then, but doesn't it then make sense to say, well, why should Felix be treated any differently?
Well, I understand what your lordship's putting to, and maybe in the end it makes no difference. But it just seems to me that as a matter of logic, start with the breaching party and then work your way up to the party who's controlling the breaching party. That just seems to me to be a logical course of analysis.
Well, you could do it either way.
It's, yeah, well, I'm suggesting that's the more logical, but in any event,
But there are real people. I mean, in the end, because there are individuals who are running these things, and probably at that, I don't know, but at that point, presumably, Felix is just being run by people at TPG.
or people on behalf of TPG.
Yeah.
Yes. I
So-
get that.
Yeah.
I get that. So the simple point we say, and I appreciate that the court dealt with it. That's not the question. The question is whether there was an arguable case for permission that all of that conduct could be inferred to be conduct in support of a conspiracy to which the acquirer of Felix, already known at this point, albeit not yet transferred, Erminosa, has been found on a serious issue to be tried standard to be party. We said it is a plainly arguable inference. Whether it would ultimately succeed at trial, well, that's another matter. Briefly, DP World, the position on DP World, they get into a joint venture.
Which one is this? This is
DP
ground floor, is
World-
it?
Ground, yes,
Yeah.
absolutely, and it's PTA scales from 87 to 92, and it's judgment 368 to 369. And DP World's representative was somebody called Mr. Chamada. And I had told you there were two meetings in August, one of which dealt with the raid and one of which dealt with the threat, 2 days apart, I think. And Mr. Chamada was at the first, but not the second. So he was at the meeting at which a corporate raid and the use of force was discussed, but he was not at the meeting at which the threat was actually.
I think that's a bit, with respect, I think that's a little bit, the wording needs to be a bit carefully
I'm sure you'll also
looked at there, because you say the word, he had used the word force. Now, if you say force will be used, that's one thing. What actually was said, I think, was that we will force this through,
That's
or something
exactly
like that.
That's
It's
exactly
a different thing.
Well,
I mean, I understand why you say what you say, but you have to be quite careful about the language.
I'm falling into the trap that is created by having to deal with things at speed and not go to each of them individually. And I apologise for that, because Your Lordship is right that, of course, you must look at exactly what. And paragraph 362 of the judgment picks it up, referring to all of that. And then there is clear evidence of the first basic element of an unlawful act conspiracy, that is the combination between them. But ultimately what is found is that there is no evidence that Mr. Chamada and therefore DP World are party to the threat that is made at the second meeting. That's the only point I was seeking to make. And we suggest, when properly viewed on a serious issue to be tried standard, and bearing in mind that the party who's behind the threat, that's associated with the threat, that is Rabinovich, Mr. Severinov, and Erminosa, with whom DP World are entering into contractual relationships, at a serious issue to be tried level, it is reasonable to infer not only that they are in combination, but that there is knowledge that what will be unlawful means may be deployed, and that would be sufficient. And that leaves, my Lord, ground 5 and Fesco, addressed in PTA skeleton paragraphs 93 to 94. And we say, given that there are findings that the conduct of Ms. Mamadzad and Mr. Kuzovkov in relation to the 3 September meeting may be coloured by the conspiracy, and given that the Cypriot injunctions sought by Halameda shortly afterwards, it having been authorised to pursue the company debt, followed. Again, at serious issue to be tried level, it is plainly a possible inference, one which we say is reasonably arguable, that Fesco itself is party to the conspiracy. I'm sorry, I missed out one thing about Mr. Chamada. He was also a director of Erminosa, or became one at any rate. So I'm instructed, if we need a reference to that, I'll find it.
At what stage?
I will ask and find out. I've been passed a note to tell me that, so I will ask and find it. So you take those grounds together, 1 to 6. 6 was Mr. Garber, who I've dealt with.
Yes.
We say they should be viewed collectively. The answer is at some point in 2020. That's not.
Oh, that was the bit. Yes, I remember that.
Yeah.
No one quite knew.
Yeah. They do raise serious issues about the judge's siloed consideration of the evidence and the arguments arising from each of the individual grounds 1 to 6, and the argument that everything should be viewed both collectively and in the light of those individual unanswered points, which were not grappled with by Lord Justice Nails, and that is the threshold that then gets us into a consideration as to whether permission to appeal would otherwise have been probable. And we do say for the identical reasons that had Lord Justice Nails grappled with all of that, rather than simply saying that the judge was entitled so to reason, that permission would have been granted. Lord, can I briefly sketch out how the other points interrelate? On Fesco, you then have grounds 7 and 8 as to gateways, and grounds 9 and 10 as to forum. As to grounds 7 and 8, 7 concerns the contract gateway, and 8 concerns the necessary and proper party and connected claim gateways. So far as the contract gateway is concerned, the debate in the end, and it is set out in some detail in the PTA skeleton, so if I just identify the references, perhaps it's judgment addressing the law 93 to 119, and then rejecting its application in the context of the Fesco conspiracy at 502 to 5. It's PTA skeleton paragraphs 96 to 104, and it is reason for refusal of permission 7 on page 21. Those are the references. And there were 3 contracts that were relied on as being related to this claim sufficient to invoke the contract gateway, the test being in respect of a contract governed by English law. And they were the 2 loans, that's the Scion loan and the Maple Ridge loan, and thirdly, the Intermere shareholders agreement. And what the judgment does is, having reached the conclusion that going after the loans was not shown to be part of the conspiracy, it is then said, well, those loans are therefore only incidental. They do not satisfy, and there's a debate about the level of the test, and I'll come back to that, but they do not satisfy the relevant degree of connectedness for purposes of Gateway 6. We have 2 points about that, which were raised in the permission to appeal application. The first point is as to the other agreement, which is the Intermere shareholders agreement. And as to that, of course, if we are right that there was an arguable appeal as to Felix breaching that agreement and being part of the conspiracy, it would be one of the key components of the conspiracy. The judge, of course, found that it was not, so I'm dealing with it on the hypothetical in that sense. But it goes slightly further than that, which takes one to the law point and to a couple of aspects about it. What His Lordship Mr. Justice Bright did in those passages is identify 2 different views, if you like, of the standard, the one in Cecil and Byatt and the other in a case called Alliance Bank. And the question is, how involved does the contract have to be? And the lower of those 2, Cecil and Byatt, had set a standard that it would be available, that gateway, if the contract needed to be referred to and relied upon. It's the phrase in the more permissive of the 2 tests. In other words, it doesn't have to be the cause of action, but the question is it going to have to be referred to and relied upon as part of it? The PTA skeleton puts up the argument that even that is too strict a test, that the test, when it is said, the words in respect of a contract, they are words of wide import. And when you consider the conspiracy, the central part of the Fesco conspiracy was to strip the SGS branch of its shareholding in Fesco, the central structure through which that was held being the intermediate shareholders agreement. Now, it's true, it changed down through other levels, and there are different things happening at different levels. But to suggest that the conspiracy wasn't in that respect one quite closely connected to the contract, we would suggest is wrong. So the law point is, the test was submitted to be wider. It's plainly an issue which would, in other circumstances, justify this court's attention, and really permission should have been given on that ground too. As to ground 8, that's gateways 3 and 4, 3 and 4A. Gateway 3, necessary and proper party. Gateway 4A is connected claims. You've got one claim against the defendant that allows you to bring in the other claim against the defendant, if you like, but it needs to be a claim against the defendant that you do have, not jumping between defendants. It felt to be considered if there was a serious issue to be tried against TPG, Mr. Garber, or Magomedov, and the judge accepted that if he had found a serious issue to be tried against TPG Garber, well, it deals with TPG and Garber, against TPG or Garber.
Not Magomedov.
Exactly, that's why I
That's a
stopped.
BVI company, isn't it?
Yes. So if he
So
had,
what you're looking for is someone who's here, is that right?
yes, there was an argument as to why Magomedov was served as of right. What the judgment records about it is that it was less convincing, but never goes into it.
Okay, so anyway,
Yeah,
but
so
it probably
let's focus on TPG
and Garber.
I accept that. I accept it. The judge expressly found that had he found that there was a serious issue on that, the remaining Fesco conspiracy defendants would have been legitimately dragged in under the necessary and proper party gateway. So it only arises separate from the consideration of that, insofar as it has a connection through to the NCSP conspiracy, which is that the question is, was the Fesco conspiracy sufficiently linked to the NCSP conspiracy that if there was jurisdiction over some in regard to Fesco, that would bring in NCSP?
But only the same people. Is that right?
Well,
no, you're still on the necessary and proper party
Yes.
bit, but
Yes.
not the other bit.
not 4A. Yes, yes.
Right, so
Yes,
say that again then.
So the second relevance of the
Yeah.
gateway. First relevance is as to the Fesco
Yeah.
conspiracy. The second relevance is to bring in the NCSP conspiracy
In full.
defendants in full.
with all the
That in turn
defendants to that.
turning on the connection between the two
Yeah.
conspiracies and being the subject of the debate
Yeah,
that gives rise to the fair presentation debate as to the role of the Russian state.
and that 26th of September letter.
All of that. And the point that's made in the PDA's Kerrison and the PLA is a simple one, which is that I've addressed fair presentation when it comes to looking at these, what might be called two cases in one case. What exercised the judge in the judgment was, well, if the Russian state involvement is irrelevant to the Fesco conspiracy, then the degree of connection between the NCSP conspiracy and that conspiracy becomes too thin to justify them being brought in on the necessary and proper party basis. That's the way the analysis works. But the critical thing that doesn't deal with is it was going all the way back to the applications for permission to serve after when a claim was first lodged, and in the hearings, always obvious that whatever the role of the Russian state vis-a-vis the Fesco conspiracy, the fact of what the Russian state then did was going to be critical to questions of causation of loss. And the reason for that is, and this is recorded in the judgment, that what then happened is first the Russian criminal court continued to run ahead against Mr. Magomedov And then Fesco filed a civil claim. And then the Russian court confiscated all of the Fesco shares. And then in the final analysis, President Putin passed a decree and he said all of those shares belong to Rosatom. That's what happened. It was the final event. So that chapter, that history, which concerns criminal proceedings, Fesco claim, Russian courts on Fesco claim, and ultimately presidential decree giving all of the shares to Rosatom, was always going to be fundamental, it's going to be fundamental to the Fesco conspiracy. And that means that
Sorry, can you explain that? I mean, I'm struggling with that at the moment because those are just facts which have happened. I mean, the court isn't going to be able. It'll make no difference whether the court thinks that those things were illegal or not in Russia, will it?
Well,
if the money's been, putting it in very brutal terms, if the money's been taken and they are not, the Russian state is not a party to the proceeding.
To the conspiracy itself or to the proceeding.
So that it can't be ordered to pay compensation or anything of that sort, because it's not a party in relation to the relevant conspiracy. Why does one then say that the two conspiracies are sufficiently closely connected that the parties to one are necessary and proper parties to the other? I mean, those are just facts, aren't they?
Can I run the analysis logically? Can I first say, as to the NCSP conspiracy, the Russian state remained said to be a party. Remained said to be a party, and one of the things that was identified in the debates of Gateway and indeed applicable law was that the criminal proceedings and the conduct of the prosecuting authorities and the courts in Russia and those who give them instructions was going to arise as an issue in the NCSP conspiracy. And the reason that this is what gave rise to the judge's concern about the change of position on Fesco, because he said all of that is going to have to be debated in an NCSP, but will not have to be debated in consequence of the letter in Fesco. And therefore there is clear blue water between the two. They don't mingle into each other, and the complicated issues as to the involvement of the Russian state arise on the one side and not on the other side. Is Lordship with me so far? So that's what the judgment found. Why is that wrong, even given the change of position? It is that one of the issues in the Fesco conspiracy claim, as in any conspiracy claim, is causation and loss. The inevitable defense amongst all of the others by such defendants as remain will be there is no loss because the shares will always, to roll it all up, in the final analysis have been taken by President Putin in any event. And therefore the comparison to your position, but for or without the conspiracy, is nothing. It was always going to be that the end result was that the Russian state took the shares. Now, when that defense is considered, an issue will be as to whether that does indeed mean that the damage caused by the conspiracy can be found by the court not to have occurred. And there are debates about remoteness, and there are debates of policy as to the extent to which you take account of all of that. And all of that is going to have to happen in the Fesco claim were it to run.
But the same things didn't happen in respect of the assets in the two cases, did they? I mean, you've just said there was a presidential decree in one case and not in the other.
They're completely different. I accept that. I accept that. The point is...
So they're very different facts. It's not, you can't just say, oh, the Russian state is somehow, has a campaign against these gentlemen and therefore it's the same case.
Your Lordship is right that, to be clear about it, the Fesco conspiracy case, if one calls it that, ultimately involves the loss of the investment held directly and indirectly in the Fesco shares.
Yeah.
The NCSP case concerns the 50% Port Petrovsk stake in Omerico, which owns a different port, and which was the subject of the sale under threat of the sale at a significant undervalue. And those two inquiries are entirely different. But as to what was going on, your Lordship will recall in NCSP, the threat was Mr. Magomedov will remain in prison.
Yeah.
The criminal proceedings against Mr. Magomedov would continue. He would remain in prison. He would be sentenced, as he has been, to 20 years jail, or whatever it is. That is accepted to be relevant to the NCSP conspiracy. That conduct is all the same conduct that will be inquired into the running of the criminal proceedings, the logical endpoint of which is the Putin decree confiscating the Fesco shares. And for that reason, and not because you are talking about the same underlying investment, it's going to end up being, if these cases were to run, proper matter that will occupy serious parts of the trial in both of them. And that would be a reason to keep the two in one case. And that was the submission. Lord, I don't know whether I've already reached my stopping time or if we end at 4:15, but
We'll end
on
at
either version I have to go at some speed.
We'll end at 4:15.
Okay. Just as to forum, ultimately on Fesco, Judge finds, well, the proper forum was Cyprus. And as to that, if there is a case against TPG, one would never get there because TPG had not challenged jurisdiction. And the judge in fact says, well, although TPG had not challenged jurisdiction, it served as a right, and notwithstanding that they confirmed that in the hearing, the inter partes hearing itself, he'd give them another opportunity to think about it, as it were, to try to persuade them to say, well, let's rather be in Cyprus. And we say that's completely inappropriate. They've made their position perfectly clear, and the judge accepted that if the case against TPG or Mr. Garber was to continue in England, then England should be the natural forum. So that's the easiest answer to ground 9 and the forum question. There is also a more difficult argument about whether, for purposes of another forum on a forum convenience test, the other forum has to be available as of right. And there's the Privy Council decision in Hindocha versus Iwala, which definitely says, in terms, in paragraph 21, available as of right. But there's a debate about whether that really reflects what the previous authorities, including the asbestos case, Lubber and Cape, had been saying, and whether submissions count. And as to all of that, we say all of that's a plainly arguable issue for this court. And as to submissions, Rosatom had not submitted and DP World had not submitted. And so we say England was the appropriate forum and Cyprus was not. Lord, I have a few minutes to just explain how the other grounds of appeal fit together in NCSP. So we're now parking Fesco and moving to NCSP. I have debated sufficiently ground 11, abuse of process.
Yes.
Ground 12, which is the Karmakov breach of duty. Then there is ground 13, which is Transnet's dishonest assistance of the Karmakov breach of duty, which obviously, in a sense, flies or falls with the Karmakov breach of duty case. Then there is ground 14 as to whether Transnet and Ms. Mamadzad are, properly speaking, parties to the SPA. And that is because there is a clause, clause 50, which expressly makes them party as affiliates and connected persons for purposes of that clause. Now, we don't say that means they, as it were, warrant the performance of Fenty on all of the other obligations. But in a simple sense, it renders them party to the contract. And if the contract is to be rescinded, which was the alternative cause of action against Fenty, then they would be parties to that.
So
and
I
that
might just need a
contract.
tiny bit more assistance on that.
I'm
So
going very fast.
no, it's all right. But so this is, sorry, remind me again, ground.
So as
This
to direct, that is non-conspiracy claims against Transnet. There is dishonest assistance of Carmichael.
Yeah.
Yes.
No, sorry, I've got that. But you
Yes,
were on
yes.
this.
And secondly, there is the question of whether Transnet is a proper defendant to a claim for rescission of the SPA, that being an alternative remedy to the conspiracy claim. And that is supported by ground 14, being the technical reasons why Transnet is in fact party to that contract. And I really don't over push this. It's dealt with in PTA skeleton paragraph 186 to 187. It was not directly addressed by the judge because, well, I think it didn't arise, and he dealt with the context of gateways at paragraph 500 of the judgment, and recorded why, in that context, he did not conclude that they were a party to the SPA. And the PTA skeleton explains the contrary argument. Then there is ground 15 as to Ms. Mamadzad, and you will recall that no serious issue to be tried in regard to that conspiracy was found as against Ms. Mamadzad. And as to that, two things. The first is, we say she was a conduit for the threat, that plainly rendered that case arguable. And we say, secondly, the slightly odd turn of events relating to the Epitekia arrangements and what Lord Justice Popplewell found to be an arguable connection between those and the conspiracy mean that there must have been a serious issue to be tried against Ms. Mamadzad in the light of Lord Justice Popplewell's permission to appeal. Ground 17 and 19 concern applicable law. 17 is as to which law, and 19 is as to Russian law of limitation. Russian law of limitation only arises if Russian law applies.
Can I just go back
Yes,
a
of course.
stage? Lord Justice Males dealt collectively with grounds 11 to 23.
Correct.
And as you highlighted, the way in which he dealt with it. So on your case, when do these other grounds arise? Because Lord Justice Males only dealt with fair presentation.
Right. So if I
you
just,
have to get over that.
correct. Yes, I agree with that. Well, just to recap my submission.
Doesn't this go more to whether, if you get over that, when we get to the stage of reopening the application for permission to appeal, how do these matters fit into your application to reopen is what I'm really asking.
And dialing all the way back to the beginning, I identified the complication that one of the requirements for reopening is the probability of a different result.
Yes.
And that means that for these grounds to be reopened, I have to do two things. I have to first persuade your lordship that Lord Justice Males did not consider them and grapple with them.
Yes.
And that the fair presentation issues are not an immovable
So you're going
obstacle.
through these to say that...
and if I penetrate that barrier,
there will probably be a different outcome if these have been addressed. I've got it.
yes, quite. So I have to do it, but I'm doing it very summarily.
Yeah, no, I understand.
And I got as far as applicable law. I said to you, ground 17 relates to whether Russian law applies at all. Ground 19 to Russian law of limitation, about which there's some technical issues. We make 2 points about Russian law in particular. First, abuse of process, going back to ground 11. Transnet had raised Russian law, potential application of Russian law, prior to the injunction hearing, and then elected not to pursue it before His Lordship Mr. Justice Butcher. That is in itself good enough to give rise to the abuse of process, and we say that His Lordship Mr. Justice Bright was wrong to reject that, and they should not have been able to contend for Russian law at all for their part. Then, of course, there's Ms. Mamadzad. The question is, could she contend for Russian law as she did? Because she wasn't subject to the abuse of process argument. And the argument set out in the skeleton on this ground is really a simple one. It is, what we're talking about is non-contractual obligations, and therefore Rome 2. And there were two of the overrides in Article 4 in play. The one is the habitual residence override, and the other is the manifestly closer connection override. As to habitual residence, you look at which party suffers the direct damage. You don't look at the downstream parties. The direct damage is Petrovsk. It's a BVI company, so it plainly is not Russian. And therefore, the habitual residence point, which the judge dealt with by reference to Mr. Magomedov, should not have been applied and doesn't come into issue. That, of course, leaves in play manifestly more closely connected, which is then the big one. And the submission in that regard is that in interlocutory stage, when the argument is that the critical agreement, which is the subject of the NSBC conspiracy, which is the Omerico share purchase agreement, is expressly governed by English law. In those circumstances, it really was not possible at interlocutory stage to reject the argument that it is arguable that it remains English law and that the override should not apply. And the rest...
Just the thing about pre-existing relationship, or where's the wording of the
article?
It's in the judgment.
It's in the authorities bundle. I should perhaps just give your lordship the reference, but I can take you to it if you'd like me to. It's in your main bundle, volume 8, tab 51, page 2349.
2349.
Yes.
Sorry.
Let me just check that reference.
Yeah.
51.
Sorry, I'm looking at the moment.
We're looking for Article 4.
And we're looking for Article 4.
It's in 307 of the judgment, I think.
Well, that is probably a better place to go then. It is on page 2350.
Which one is it?
If my Lord Justice Miles wants to find it in the authorities.
No, sorry, I'll look at it in here. So
2350, where it is clear from all the circumstances of the case that...
yeah, sorry, the bit I had in mind, sorry to jump ahead, so is manifestly close connection with another country might be based in particular on a pre-existing relationship between the parties, such as a contract that is closely connected with the tort in question.
So we're in the inverse of that problem, if I can put it that way. What is found is, by Justice Bright, is that the tort, that is the conspiracy, is manifestly more connected to Russia.
Yeah.
The competing argument was, it's all about, this whole thing is about the contract, and the contract is subject to English law.
You're not saying you're not saying it falls within the words of Article 4.3, are you? That contract, because it's not a pre-existing contract, because it's a contract which is entered into pursuant to the conspiracy. This seems to be talking about a case where there's a pre-existing relationship between the parties, which might very well be the thing that shows you, therefore, where the connection is.
Well, if we then back right up, you start in paragraph 1 of Article 4, which is the law applicable to a non-contractual obligation, so a tort, shall be the law of the country where the damage occurs. And our submission as to that is the Port Petrovsk damage takes place where Port Petrovsk is, which is in the BVI. That is then capable of being overridden, either by paragraph 2 or by paragraph 3. Our submission is paragraph 2 doesn't apply for the identical
Yeah.
reason because Port Petrovsk is not in Russia. That leaves paragraph 3. The question then is, notwithstanding that the damage has taken place in the BVI, arguably, is it clear from all of the circumstances of the case that the tort is manifestly more closely connected with another country, in this case, Russia, in which case that might apply. It's an override provision. And your lordship is right that it identifies one reason why that might be so, as where there is a pre-existing contractual relationship. It was not advanced on the basis of a pre-existing Russian relationship. So to that extent, that example doesn't assist.
No, but I thought you were saying, well, the answer
Hang
was
on.
the contract.
Yes, if I can finish the proposition. So it was based upon the first sentence of
Yeah, no, I
paragraph.
understand that. It was your
And
submission.
what I say is that when considering whether it is right to displace paragraph 1 in favour of paragraph 3 of Article 4 on a manifest connection basis, closer connection basis, another relevant factor is that the instrument of the damage is an English law contract with a BVI company. And in those circumstances, the submission is, you could not, at interlocutory stage, reject the arguability of the proposition that Russian law should not override under Article 4.3.
All right.
I hope I've now put it
Yep.
as fully as it required. Lastly, gateways, which is ground 18. If English law applied to the contract for that reason, well then gateway 9C would apply. And otherwise, sorry, I beg your pardon, I'll start again.
That's English tort, is it?
I went a bit fast.
Yeah.
Quite right. If English law applied to the tort on the basis that the damage took place in BVI or England, well then that, if it was English law, if that was the conclusion, I appreciate that there's some jump there. Gateway 9C would be available, but it may be it's BVI. But the contract gateway otherwise applies for the reasons I've already covered. The Americo SBA was not incidental. It was the very means by which the damage was inflicted. And that being so, this was a claim under that gateway in connection with that contract. And then, of course, there's connected claims. If Transneft and Ms. Mamadzad were parties to the contract, well, then the claim for damages would be a claim relating to the contract, and a conspiracy claim would then be another claim. But that's a deeply sophisticated proposition further down the logic of the matter. Well, can I bring it all back together? And I really apologise for taking so much time. I set out the law as to 5230.
Yes.
What the Mariana decision shows is that the key question, the key first question, is whether the Lord Justice of Appeal grappled with each of the material grounds. So, for present purposes, each ground of appeal. I accepted that it is possible, of course, where one ground creates an obstacle, and if you can't pass through that ground, you can never get to the rest, that it might be legitimate to confine the analysis to that first ground. But what I said was that is not so, where you need to consider the other grounds in order to reach a conclusion on that one, which I say on fair presentation you did. And in any event, we have the other answers as to error in regard to fair presentation, which we say Lord Justice Males just didn't engage in at all. And therefore, Lord Justice Males never got to grounds 12 to 19, respectively. And for the reasons I've treated very, very quickly, but are addressed in more detail in the permission to appeal skeleton, we say that had he considered those, he would probably have given permission. And that would satisfy this application the reasons for this application, so far as the NCSB conspiracy is concerned. And as to Fesco, we say properly considering everything together, the case against the discarded defendants should not have been discarded. And we say the gateway and jurisdiction and forum grounds then follow behind. And for those reasons, we do invite you to permit reopening of this appeal and to give permission on grounds 1 to 23 and to give permission, insofar as it matters, for an 87-page permission to appeal skeleton, subject to such other orders as lordships make it.
One, just thinking about where it might go to, because we'll obviously have to think about it, is that we've asked you to address this on the 5230 application, which you've done. It's possible that if we think there's anything in that, on any part of it, we would then have to think separately about whether permission to appeal should be given on any particular grounds. And it may be, and we'll have to think about it, that might involve some oral hearing involving the defendants.
On the identified grounds, they're subject to the identified ground, or on
everything, as to whether or not permission to appeal should be given, and if so, on which grounds. But that will be, it seems to me, a case management question as to how that would go forward.
I completely appreciate all of that, and we would make ourselves available for whatever it was that your lordships then decided ought to happen.
Yes, I think what my lord is saying is not all or nothing.
There are some intermediate steps which
there
might
are some
be taken.
intermediate steps which may, but we will, and it will become apparent from our judgments when they're provided to you in draft, where we've got to. In other words, what additionally might be required.
And should anything additional be required, and should that be because I've taken too much time on the application, I apologize.
No, it's not that. It's a separate point. So, well, thank you very much for your comprehensive submissions.
Thank you.
And thank you for everybody else involved in them. So we are going to reserve, obviously, our judgments. They'll be provided to you in draft in the usual way for the usual limited purposes. In other words, they can't be used for purposes other than for pointing out errors in grammar, and we'll deal with the order at the same time. Maybe simple and maybe more complex.
Yes, I get that.
Either way, we would anticipate dealing with that on paper.
Certainly.
So, unless there's anything else? No.
Oh, yes, there is one other thing. Sorry, would you make sure that the transcript is provided to our clerks?
I have no idea where it is, but I will.
But then,
I will ask questions and find out and make sure. Yes.
Thank you.
Thank you.
Thank you very much.